Mr. Sinclair.
Good morning, my lords. I appear with Mr. Jane on behalf of the appellant Al Othman. Mr. Westwood and Mr. Connell appear on behalf of the respondent Al Rajhi. As your lordships will have seen, this case concerns a claim brought by Al Othman under a written loan agreement dated the 24th of November 2014, which provided for the immediate payment of $5 million by Al Rajhi to Al Othman. And the background, my lords, to that agreement, as the judge herself found, was that in 2008, Al Othman had agreed to invest in a company called Newtech. That investment was made through an entity called Al Salam Energy. In total, Al Othman invested about 5.7 million for approximately 10% of the shares in Al Salam. In 2014, Mr. Al Othman became concerned about the performance of that investment and informed Mr. Al Rajhi that he wanted to exit the investment in Newtech by selling its shares in Al Salam. Mr. Al Rajhi, however, expressed a concern about other shareholders being notified because of the terms of the Al Salam shareholders agreement, and therefore he proposed that the transaction or exit be structured as a loan. Mr. Al Othman agreed to that structure, and ultimately the loan agreement was entered into. Now, the effect of the loan agreement, therefore, was that Al Othman didn't actually sell its shares in Al Salam, but instead Al Rajhi agreed to pay $5 million immediately, and Al Othman agreed to confer a security interest in its shares in Al Salam and to repay the loan out of any future distributions that might be made.
We are concerned, are we, with a contract to lend. Nobody's suggesting it's a sham or anything like that. We are to respect the structure that the parties have chosen.
That's correct, my lord.
And under the contract, your client is the debtor, the defendant is the creditor, and the creditor is to be repaid out of the distributions.
If any, yes.
Right. What is your cause of action?
It's a claim under that loan agreement for...
What is it? It's not a debt. What is it?
Well, it is a debt, my lord. It's a claim under Clause 1 for immediate payment of the $5 million.
If I agree to lend money to you, and I don't, am I your debtor?
Well, perhaps it's helpful just to turn up the loan agreement, because the cause of action was based on Clause 1, it's supplemental bundle,
yes,
page 6. And perhaps you've looked at this already, but the clause provides that the lender shall make available to the borrower, and the borrower agrees to borrow the loan on the date hereof. And the parties understood this loan agreement to operate in a particular way. Indeed, that's recorded, at least in relation to the verbal discussions between the principals at paragraph 86 of the judgment, that what the parties were looking to achieve via this agreement was an economic exit.
Well, I follow that, but you said that this you are relying on this as a contract to lend.
Yes.
Despite the fact that the economic reality may be something different, but we're not going behind the structure that the parties have chosen.
Yes.
So my question is, who owes money to, who is the debtor? What is the debt?
Well, we say the Al Rajhi company owes the Al Othman company $5 million pursuant to Clause 1, and that's the way the case was pleaded and the basis on which the case proceeded below.
If my bank agrees to make an overdraft if I available to me of $5 million, and it doesn't, I can't sue it for $5 million.
Well, with respect, my lord, the particular context, we submit that one has to have regard to the context in which this agreement was formed, and the...
It's a loan. It says, paragraph 1, the lender shall make available to the borrower, and the borrower agrees to borrow.
Yes.
So you can't sue for that.
Well,
you can't sue for the amount of the loan.
Well, my lord, this point hasn't been taken to date. I mean, the case has proceeded on a particular basis, and we say that the parties understood that this was effectively an arrangement by which, although it's referred to as a loan agreement, we say that this did create a debt, and that was understood by both parties.
Why don't we see that in the pleadings?
Well, we see, as it were, well, what we don't see in the pleadings is any suggestion that this agreement did not qualify for the purposes of Section 29, as it were. There are lots of defences taken, but the defences taken are it's not binding and so on. It's not said that the example, for example,
So you're saying there's some estoppel by convention? If you haven't got a cause of action for a debt, how do we, as my lord said, how do we get it?
Yes, well, we obviously don't accept, my lord, that there isn't a cause of action for the debt, because we submit that the way the parties understood this was effectively to create that obligation to pay the 5 million. And
I can see if it was a sale, then that would be right. But
yes,
but it isn't.
no, I understand what your lordship's putting to me, but if, for example, can I just perhaps show you, because we say that the parties understood that this was to achieve a sale, and the idea to structure it as a loan came from Al Rajhi. And paragraph, if one just looks, for example, at paragraph 86 of the judgment, so that's C45. The position, if you have paragraph 86, the position was that the parties understood and agreed, it was never in dispute, that an agreement was reached orally between Mr. Al Othman and Mr. Al Rajhi for the defendant to make a loan of $5 million to the claimant as a way of allowing it to monetize its stake without actually selling it. And there's then obviously a question as to what happens to that agreement between the two principals, and I think your lordships will have seen there's a debate about that. But we say that this agreement between the principals is then reflected in the loan agreement. And so we submit, and as I say, this has not been a point that's been contentious hitherto, that the loan agreement, although they deny that the loan agreement was binding and so on because of agents' lack of authority and so on, it's not, it hasn't been said that it's a loan and therefore you can't sue as a debt on a creditor-debtor basis. So that's the way in which the case proceeded below. And in my submission, one has to look at the wider context and not merely clause 1 in isolation.
So does that mean that you are, in effect, asking us to go behind the agreed structure
No, my lord, I'm asking...
and treat it as a sale?
Well, in my submission, and I'll come on to explain this, the parties understood this to operate as a sale, and there's contemporaneous material which refers to it as a sale. And the judge has made various findings about how the transaction was considered, both internally within the Al Othman side, internally within the Al Rajhi side, and there's material which crosses the line, referring to the transaction as a sale, even after the structure was designed as a loan. So one of the points I was going to show you is there's a document which doesn't appear in the judgment, which postdates the discussion in September between the principals when Mr. Al Rajhi said, can we structure it as a loan? There is then a communication which crosses the line where the parties are nonetheless referring to this as a sale. And that's, so I'm not asking, as it were, for you to go behind the written agreement. I'm asking you to proceed on the same basis as the parties proceeded as to how this agreement was supposed to work.
But on what legal basis?
Well, on the basis that the contract has to be construed in the light of all of the factual background, and the evidence is clear that the parties understood this to be a sale. That's what my clients wanted on day one, and it was at the instigation of Al Rajhi that it was structured in this way. And we say it wouldn't therefore be open to them to say this isn't a proper loan.
The whole point was they couldn't do it as a sale, because if it had been a sale, they would have had to disclose it to the other parties. So it was agreed that they wouldn't do a sale. They would have a transaction that would give the same economic effect as a sale, but it wouldn't be a sale, because if it was, they'd have to disclose it.
That's right. That's
So
right.
It wasn't a sale. It was the way that it was structured was the way, presumably, it was meant to operate.
And it wasn't quite a sale anyway, economically, because if the company had, perhaps against expectations, been sold for a higher amount, then your clients would have benefited to the extent of the excess over the loan.
Well, your lordship's right about that. That's a point that I do accept. That is, as it were, a scenario for which this agreement doesn't legislate. I do accept that. But on the broader point about loan versus sale, in my submission, it would be artificial to read this, as it were, on the basis that this is a traditional loan, given that the contemporaneous material clearly shows that the parties wanted to achieve effectively a sale in substance.
Well, you started this submission by saying quite rightly that the contract has to be construed in the context. But what are we construing? Are we construing clause 1 to say that when it refers to a loan, it means proceeds of sale? Is that?
Well, in my submission, it's when it's referring to what I need to establish, and the point that I'm making is that clause 1 does create a debt. That's the ultimate point, and I do understand that the point that's being made, which is it obviously refers on its face to this being a loan without more. But in my submission, one has to read the reference to this being a loan agreement against the background, and the background involves looking at what the parties understood this actually to create in substance, and in substance, subject to the point that my Lord Justice Mells has just made, which I do accept, but in substance, all of the material predating the loan agreement, it points in one direction, that this was to create a debt obligation. Indeed, I do emphasise this point was not taken below, and in my respectful submission, it would be a deeply unattractive point for the other side to have taken below, in circumstances where they were the instigators of this structure, because my clients wanted to exit, as you will have seen, wanted a sale, an outright sale, and that's the way in which the negotiations took place to begin with. And so that in my submission, there's actually quite a good reason why this point wasn't taken below, because it wouldn't have, in my submission, it wouldn't have been open to them to suggest this was a loan stricto sensu. My Lord, I was on the basis that this does create a debt. I was just going to explain that by the time of the trial, although there were a number of defences taken, by the time of the trial there were two main issues. First, was Rajhi bound? And that raised an authority question, and the judge rejected that point. And at paragraph 114 of the judgment, perhaps just worth looking at that. She found that there had been a discussion between Mr. Al-Sharifi, who signed the agreement, and Mr. Al-Rajhi on the day in question, the 24th of November. So she decided the authority question on the basis that a discussion, paragraph 114, must therefore have taken place on about 24th of November, in which Mr. Al-Rajhi gave Mr. Al-Sharifi to understand that he could agree to the terms as they then stood. And on the second issue, as you know, the question of whether there had been an acknowledgement under section 29, her reasoning is contained in the paragraphs 150 to 155. And on this appeal, the question is whether that reasoning is correct. And we say there are, with respect, a number of problems with the judge's reasoning on the acknowledgement issue. And I was going to take you actually straight to the email exchange to summarise the points that we make in relation to the construction of that email exchange. That's supplemental bundle tab 9.
Yeah.
and
S35, is that the one?
exactly, my lord. So the first email starts at the bottom. Mr. Matar from the Al Rajhi side on the 29th of October, subject to new tech distribution, and you'll see it's addressed to, amongst others, Mr. Riz. And he refers to the fact that new tech has a distribution which he's proposing to make. And then Mr. Riz responds, as you know, we already sold our shares to Rajhi Holdings, but we didn't get our funds yet. Will the below dividends be considered as interest? And Mr. Matar replies, based on my understanding from Mr. Al Rajhi, so that's the same individual who authorised Mr. Al Sharifi to sign the loan agreement on the judge's findings, this amount is to be considered towards the amount due as mentioned below in your email. Now, in terms of the principles, I was going to come on in due course to show you some authority on section 29, but those authorities make clear that it is sufficient for section 29 purposes that a debtor acknowledges that something is due. All there needs to be is an acknowledgement of general indebtedness, and then extraneous evidence can be used to identify the debt in question. And our simple point is that the starting point in construing the email exchange is to focus on the words in the email, and crucially, what Mr. Rizk is referring to is a transaction that has concluded. We already sold our shares, but we did not get our funds yet. When Mr. Matar responds, referring to the amount due, we say that is equivalent in line with the authorities. That's equivalent to saying, I owe you some money. And those words, amount due, are crucial because they represent a recognition that something is owed by Al Rajhi to Al Othman. And those words, amount due, don't appear to have been considered by the judge in the paragraphs that I mentioned, 150 to 155, which I'll show you in due course, nor did she cite or refer to the three Court of Appeal authorities that I'm going to take you to in due course. And we say she effectively applied a standard which was too high, or a bar that was too high in construing this exchange. And in particular, she seems to have rejected our case because the email exchange refers to Al Othman having already sold our shares. We say that, in fact, that reference to a sale, again, construing this in context, was understood by the parties to be a reference to the loan agreement. There was no other transaction between these parties in relation to Al Salam or Newtech. And so we say, and the judge herself found that the parties had agreed to structure this transaction as a loan, even though it was to effect a sale in substance. I'll show you the relevant paragraphs. So we say, against the background that was known to these parties, we already sold our shares, but we did not get our funds yet, can only have been a reference back to the loan agreement. And therefore, when the Al Rajhi email refers to the amount due as mentioned below, that again can only be referring to the loan agreement.
I understand you've moved on from the questions we were asking you at the start, which were about, I think your answer is, well, whatever the legal position, which I don't think you said is actually a loan, it's just the parties are treating it as a loan, or it should be construed as a loan, as a debt. But surely when we look at whether this is an acknowledgement, it has to be construed objectively. So one does actually have to look at whether there was an amount due as a matter of law, don't we? You can't say that it's referring to an amount due if there isn't.
No, that's right. I mean, plainly for section 29 to work, that there needs to be an acknowledgement in respect of a legal liability. I obviously accept that. But then that takes one back to the question of whether the loan agreement created an obligation to pay.
There's two questions there, isn't there? There's what was the position at the time, which was how are the parties treating it now? And my understanding is you're saying to us, well, the parties are now treating it as a debt, or they have the respondents haven't argued otherwise below, but that doesn't answer the question of what was the position in 2018.
Well, in my submission, it's a consistent line of argument, which is to say the parties, if one goes all the way back, and I'll take this in stages, if one goes all the way back, my clients wanted to sell. Rajhi said, can we structure this as a loan in order to avoid triggering the tag-along and so on rights under the shareholders agreement? That then leads to the loan agreement being entered into, but it was understood, now again I'll show you the material, it was understood by all sides that in substance that agreement affected a sale. And the documents, we'll see this in due course, but the documents refer to the transaction interchangeably actually, as a loan and as a sale, and there's also references to a buyout.
But they're different legal structures. I mean, if your position was, well, the whole thing was just a sham, and this was a sale, and you can forget the loan agreement, I could understand that, but that's not your position. You say that we must respect the structure chosen by the parties. This is a contract of loan.
Well, I don't. To be clear, I'm not. You're right. I'm not suggesting it's a sham, but I am saying that clause 1 creates an obligation to pay, and indeed, very early on in these proceedings, the Rajhi side took a point on the construction of clause 1, saying that clause 1 of the loan agreement doesn't create an obligation to pay because it refers to, I think it's either the date, it's the immediate date or any date that might subsequently be agreed. The lender shall make available, yes, agrees to borrow the loan on the date hereof or such later date as may be agreed between the parties. And they sought to suggest, and pleaded in fact, a case that there was no binding obligation under clause 1 because of the reference to or such later date as may be agreed between the parties. And in fact, we struck out that defence in front of Mr. Justice Foxton, and that was on the basis that clause 1 gave rise to an immediate obligation to pay. So not
might be an immediate obligation to make the loan.
Yes.
But that doesn't mean it's a debt.
Well, that comes back to my submission that the parties understood this to create a debt, and so it would be artificial, in my respectful submission, to impose upon or to interpret this agreement in a way that's contrary to the way in which the parties clearly understood it to operate. So the whole.
Did Mr. Justice Foxton give a judgment?
He did give an extemporary judgment from memory. It's certainly not in the bundles, but we can dig that up.
Well, it may be relevant to see what he said, because I suppose if he said in the judgment that there was a binding obligation to pay, and there was no appeal from that judgment, then this may be water under the bridge, I don't know.
Yes, well, that's certainly the submission I'm making, albeit based on my recollection of, I would need to go back to see the terms of his judgment, but there's certainly the dispute between the parties at that stage was not the discussion that we're having, but it was a question of whether clause 1 gave rise to any binding obligation. Because
we could see his judgment and any material we need to see to understand.
Yes, I mean, can I just check if I don't recall seeing it in the bundles.
No, that comes as news to me.
Yes, there were various lines of defence which we struck out, and it was actually the first case management conference, as I recall, that this particular point was disposed of. You do have a copy of the defence in the core bundle, tab 7, and it's not controversial that the point which you're now putting to me was never taken below. So I make 2 points.
Which was the paragraph here that was struck out?
Let me. So as I recall, my lord, if your lordship could turn to page C90. as I recall, but I will want to just go back and make sure that I'm correct about this. It's the line of argument at 14.2.
Yeah.
So perhaps for clarity, I'm making 2 points. One, the point that this didn't create a debt was never taken. That's point one. But then point two, in addition, in fact, the only point was taken that there was no, the point that you can see at 14.2, there was no binding obligation because of the date, and we struck that out. And so we would say the effect of striking out successfully that line of argument is that the court has found there is a binding obligation for Rajhi to make an immediate payment. I do understand the point my Lord Justice Phillips is saying, which is, well, that could be an immediate obligation to pay the loan. I understand that, but we would respectfully submit that the parties did understand this to operate in a particular way, and in that particular way was to create a debt obligation. So I'm not saying it's a sham, I'm saying it was understood by the parties to operate in this way. The point was never taken. Moreover, we struck out that line of defence, and the consequence of striking that out is, as it were, the court has already found clause 1 did give rise to an immediate obligation.
If forgive me again, if they owed you the debt, then there couldn't be any obligation on you to repay, could there?
That's right. That's right. But the parties
There is an obligation on you to repay.
yes, but only out of effectively new tech distributions. So, and that, in my submission, reflects the way in which the parties again understood this transaction to work. Because what the parties were looking to achieve was to put Rajhi in the position of being the economic owner, and that.
Forgive me, I think we really do understand that the parties would like to have done a sale, made a sale. They couldn't because of secrecy. So instead, they structured it as a loan with repayments to be made out of the distributions.
Yes.
I don't see any problem with that at all. But my understanding is it isn't just that that's what how they agreed to structure it. That was the legal reality, because that's why they signed an agreement in that form. So I don't really understand how one goes any further than that, and how one then says this is a debt, because it isn't, it's a loan.
Well, you have my submissions on. I'm not sure I can take that point any further.
Then how can we then argue about whether this is when there's an email referring to the amount due, that is acknowledging a debt.
Well, I see that, but that then just takes me straight back to my point that it would be wrong to interpret this in a way that is contrary to the way in which the parties plainly understood it at the time.
Well,
So
you might be able to say that if it's not a debt, it's an other liquidated pecuniary claim, to which Section 29 also applies.
Yes,
Might be your way out.
yes.
But I think there are, like my lord, it seems to me there are formidable difficulties in characterising this as a debt.
Yes. Well, we did originally plead the claim, I think, with a claim in damages in the alternative. But I do maintain
Don't
that.
think you did you?
It's page 74, the core bundle.
74. I was looking at the claim form. Well, if it's a claim for damages, then Section 29 doesn't apply.
No, I understand. That's why I'm not seeking to move away from the fact that the case has proceeded on the basis that this was a debt. I do maintain that position. And as I say, that the way in which the whole case has proceeded was that this did create a debt obligation subject to the points that were taken in the defence and which were ventilated at trial. Given there were multiple defences taken, multiple rounds of amendments, this was never raised at trial, we would say, and I did make this point earlier, but we would say there is in fact a good reason why the other side didn't take this point, given that they themselves were the instigators of this structure. So, my Lord, I mean, for the purposes of this appeal, I'd respectfully suggest that one has to proceed on the basis that the case proceeded below, and on the basis of the way in which the parties pleaded it. And we say they have accepted that this is a debt, and the only points they've taken are the ones that you can see in the defence. I mean, had they taken, for example, the point that this didn't create a debt, then we would have obviously been able to address that in the proper way and at the proper time. But in my submission, it wouldn't be appropriate for my learned friend now to jump up and say, "Oh, well, this never created a debt," because that is a completely new point, which is just never surfaced. So, my lord, I was proposing to address you on the footing that this does create a debt, and we say this email exchange, if that is right, then the reference in this email exchange, supplemental bundle, page 35, can only be referring to the amount due. And indeed, in my submission, the reference to the amount due is to a legal liability, and the legal liability is the one under the written loan agreement, because again, the parties understood that the loan agreement created an obligation to pay the 5 million. Now, can I just make two further introductory points? So one is that the judge, I've already made the submission that she focused on the need for this exchange to have referred to the loan agreement or to a loan, and we say that the parties understood the reference to a sale to be a reference back to the loan agreement. And the further point is that the judge seems to have regarded it as crucial that neither Mr. Rizk nor Mr. Mattar nor Mr. Al-Rajhi on her findings had seen a copy of the signed loan agreement. And that's a point relied on heavily by my learned friends, saying that for us to succeed on this appeal, you would need to overturn the judge's findings of fact. And I'll come on to explain our position on that in due course. But the headline point is the primary way in which we put our case on the appeal does not require this court to overturn any findings by the judge. But we do, in the alternative, say that her finding that Mr. Al-Rajhi, at least, the principal who authorised Mr. Al-Sharifi to sign the document, her conclusion that he was not aware that a transaction had been concluded, we say that was irrational. But as I say, that's our alternative case. Our primary case doesn't involve overturning the judge's findings. And the final point, by way of introduction, is to say something about my learned friend submissions, because they refer repeatedly in their skeleton argument to what they call and define as the verbal agreement. You will have seen that defined term. And to be clear as to how that fits in, what they're intending to do through this defined term, the verbal agreement, is to try to capture the discussions that took place between the principals in July and September 2014. Those are referred to in the judgment at paragraphs 39 and 51. And what they were arguing at trial was that this email exchange, when it referred to the amount due, their case at trial, their positive construction of this email exchange, was that the parties were referring back to those verbal discussions. And therefore, the position that the judge was faced with was two competing constructions. We were saying this could only be a reference to a transaction that had actually concluded, and the amount due being to what the parties understood to be a legal liability. They were arguing, no, this was a reference back to the discussions which predated the written agreement. Now, the judge did...
Those discussions were not ever said, were they, to give rise to a binding obligation?
They were not. They were not, no. That's recorded at judgment, paragraph 86. But in my submission, this reference to the verbal agreement is actually a complete red herring, because those discussions culminated in the written agreement. So it was, in my submission, it was always not a common sense construction.
If there's only ever a non-binding agreement, there wouldn't be an amount due.
Exactly. Exactly. Now, the point that I'm trying to stress at this stage is that the judge had these two competing constructions being advanced by the parties, and where she ended up was actually rejecting both sides' constructions. So she did, obviously you've seen at 150 to 155, she rejected our construction. She said this is not a reference back to the loan agreement, nor did she accept the other side's construction, that this was referring back to those non-binding verbal discussions. And ultimately, therefore, what has happened is she's decided this case on the burden of proof. And that is actually clear from, if you turn up the permission to appeal ruling at core bundle page 26, behind tab 3. Under ground 2, this is the judge's reasons for refusing permission. Do you have ground 2? On the facts as the court found them no objective basis, so that's a restatement of her conclusion. But then she said this is not necessary for any alternative construction to be available. The burden of proof is on the claimant to make a case of acknowledgement, which it failed to discharge. And so we say, again, I'll come back to this point, but we say,
At the moment, see what's wrong with that. It was your burden to establish the acknowledgement.
yes,
You did it on the basis of a particular interpretation of the email exchange.
yes.
The judge rejected that interpretation. Why did she have to say what it meant? As
Well,
long as it didn't mean what you said it meant.
Well, because as I mentioned, the other side were putting forward a positive construction.
Hmm.
And they said, no, it means what they say it meant, which was a reference back to...
And the court could say it doesn't mean either.
Yes, well,
You don't have to decide what it does mean. All we need to decide is whether it amounts to an acknowledgement or not.
Yes, but in my submission, where the parties, each of the parties are providing no one's saying, or was saying before the judge, that this was just a completely incomprehensible email exchange that was just not understood by anyone at the time. And therefore it must have borne a meaning. And we say the judge did have to articulate a positive construction in those circumstances. But
Not like finding a fact where one has to find one way or the other on a question of interpretation. All the judge has to decide is whether your interpretation is right or not.
yes, but my lord, as I say, the position at trial was that there were two rival constructions, and having rejected both, we say that that's slightly surprising because the outcome, therefore, is this email just means nothing.
That's not a burden of proof question.
Well, we say that the question for the court under section 29 is what would the recipient reasonably have understood, and that question has not been answered by the judge in terms of what this document did mean.
Why did she have to answer it?
Because as I submitted a moment ago, because it must have had a meaning, and when the parties, having called the factual witnesses and so on, provided their versions of what this email exchange meant, we do submit that it was incumbent on her either to pick one, or if she was going to reject both of them, to say what this did mean. But obviously I don't need that point. That's so my lords, I was actually proposing to divide the main submissions into the three parts. I was going to highlight some of the facts as found by the judge, which we say are relevant context for the construction of the 2018 email exchange. And I want to show you, if I may, one or two contemporaneous documents. And then secondly, I want to take you through some of the authorities, decisions of this court on section 29, and then come back to develop the submissions on why we say the judge's analysis of this email exchange was erroneous. So could I ask your lordships to turn up the judgment, please? And I'll take this quickly because obviously I do appreciate that the court will be familiar with the terms of the judgment. But, the first thing I wanted to show you, perhaps in light of the discussions we've been having this morning, just to remind your lordships, paragraph 3, it references to originally in 2013 Mr. Othman wanting to exit and repeating his wish to sell in 2014. And then, as we've discussed, at the end of paragraph 3, try to accommodate the wish on the basis the deal should be kept confidential. And then one sees a reference to the loan agreement, and you'll see at paragraph 6, the defendant does not dispute there was an agreement in principle for a $5 million loan to be made, but it maintains that Mr. Al-Sharifi had no authority, and furthermore contends the claimant's claim is in any event time barred. So those were the two main issues at the trial. And then if I could ask you to turn to paragraph 38. Where she refers to the discussions starting in late 2013, and you'll see again the discussions at 38 and 39 were about an exit and about a sale, and obviously you have that point, and this continues over the page through to paragraphs 43 and 44. So in the early discussions, this was all about a sale. And then 45 is the point in the chronology when the Al-Rajhi side draw attention to the obligations in the Al-Salam shareholders agreement. And you'll see at 48 that it was floated for the first time by Mr. Al-Sharifi. He's on the Al-Rajhi side. The defendant could simply agree to lend whatever value was agreed with a mechanism for adjusting any shortfall. This would successfully achieve the claimant's objective of an economic exit while still complying with the SHA and avoiding the need to alert the other shareholders. And at 49, that alternative structure is referred to and is agreed. And then there's an important discussion at 50.
That wasn't carried through, was it? The defendant could agree to lend whatever value was agreed with a mechanism for adjusting any shortfall or excess on exit in the future. That bit didn't find its way.
That's right. The key discussion is over the page, my lord. That's absolutely right. The key discussion between the principals is at 51. So this is the 25th of September 2014. And she finds that a discussion or meeting did eventually take place between Mr. Al-Othman and Mr. Al-Rajhi, during which Mr. Al-Rajhi agreed that the defendant would effectively underwrite the value of the claimant's initial investment so that it at least did not lose money. Following that conversation, Mr. Al-Rajhi informed Mr. Al-Sharifi that it had been agreed the defendant would pay the claimant $5 million at the end of the following month, with the amount to be documented in a loan structure. And that's why I was mentioning earlier the need to look at all of this in context, because the agreement between the principals, I accept at this stage non-binding, but this is the agreement that gets then captured by the written agreement. It's the defendant would pay $5 million at the end of the following month. And you'll see the remainder of 51. And perhaps I could just at this point just ask you to jump slightly ahead in the judgment, but still in terms of the chronology, sticking with the discussion in September, if I could ask you to look at paragraph 86. That's the paragraph I mentioned to my Lord Justice Mayles, that there's never been any suggestion that these oral discussions between the principals are themselves binding. But that's the agreement in principle, as it were. Now, I wanted to show you a document at this point, if I may, because a few days after that discussion between the principals on the 25th of September, there was an email exchange which doesn't appear in the judgment, and that's why I'd just like to show you that. It's on the 30th of September. So could I ask you to open the supplemental bundle, please, at page 10.
10.
10. It's tab 3, page 10. And so this is a communication between the parties. Mr. Abraham is on the Al-Othman side. If we start at the bottom, Mr. Abraham is on the Al-Othman side and Mr. Al-Sharifi on the Al-Rajhi side. And he says, hi, any update on the sale contract? Then the response is, I've instructed the lawyer to draft an agreement. And so again, we say this is important background because although by this stage, the 25th of September, you've seen what the principals had discussed and agreed, it was nonetheless still being referred to as a sale contract. And that's, that description wasn't, as it were, controversial or repudiated. Then if I could perhaps go back to the judgment, just to continue with the chronology, what one then sees, because that document doesn't appear, so we're still in September, paragraph 51. The document I showed a few days after that discussion at 51. And then you see from 55 to 59 some back and forth between the parties as regards the draft loan agreement. And then can I show you, please, paragraph 60, because this goes to one of the issues about knowledge, which I'll come back to later. But on 24th of November, which is the date on which the loan agreement was executed, Mr. Al-Rajhi, the principal, received an email from the group CFO informing him that the receipt of 22 million was expected that day. The last paragraph noted that certain payments, including loan to Othman, are some of the major commitments that will be pending. So he was made aware of that on the very same day. And then at 61, that same morning, Mr. Al-Sharifi sent Mr. Abraham an executed copy. So that's the 24th of November. And then could I ask you to go to paragraph 99, please?
What's the 18.75?
Yeah, it's the Saudi currency, which is equivalent to $5 million US dollars. I was then just trying to continue with the chronology. So can I then take you to 99, please, paragraph 99. And I need to take this paragraph just slowly because there's an error in the chronology in the judgment, and I just want to make sure that I've clearly explained the chronology underlying these documents. So what's referred to at 99A is, so these are minutes of the Al-Rajhi Family Council, and you'll see at 99A that there was a meeting on the 28th of October. That's before the loan agreement was executed, obviously. And could I ask you to turn up in the supplemental bundle the document that was before the Al-Rajhi Family Council on the 28th of October. So that's supplemental bundle, page 13. And halfway down the page, under the section 5 corporate update, you'll see investments. And third sentence, as for New Tech, it will neither be exited this year or next year, as the group has now opted to invest additional resources in New Tech. So this is before the loan agreement is entered into. It's being referred to as opting to invest additional resources. And then the next meeting, if you turn to page 22 of this bundle, the pack for the next meeting, which postdates the execution of the loan agreement, you'll see at page 22, most of it's redacted, but you'll see including acquisition of additional shareholding in New Tech. Do you see that? Page 22. So if one then goes back to the judgment.
So what's the 7 million?
Yeah, I mean, I don't have an answer to that in the sense that this is an Al-Rajhi document, but in my submission that the acquisition of additional shareholding is a reference back to the transaction that we're concerned with, and indeed the judge. I was just about to show you what the judge finds in relation to this, but I'm just trying to get the chronology straight. So I've just shown you two documents, one before and one after the loan agreement, and then if one then goes back to 99 of the judgment. At 99A, do you see that she quotes the passage we've just looked at? So corporate update, including acquisition of additional shareholding. I agree that this is likely to have been a reference to the loan transaction, but since the loan agreement had not been finalised at this stage, it could not have been approved at this meeting. So just taking that in stages, the judge has found that the reference in this document to acquisition of additional shareholding is likely to have been a reference to the loan transaction between the parties. But the chronology has gone awry in the sense that this is a document that postdates the loan agreement. And in my submission, that is important because it shows that the Al-Rajhi side were continuing to recognise this as an acquisition. even after the loan agreement had been entered into. And if you then continue down the subparagraphs in 99, you'll see she refers to 99B, family council meeting, other updates agreed loan structure with Al Othman Group against their stake. So this is after the loan agreement. But then she says the meeting pack for meeting number 27 contained the same note, except that it referred to a loan buyout. And that is why I said earlier that the parties are using loan and sale interchangeably, both when they communicate with each other and also internally. And then at 99C, she says it's clear that Mr. Al-Rajhi approved these pacts. I would have looked through them for that purpose. So that's what I wanted to draw your attention to on the chronology. And now can I turn to the case law on section 29, please, and then come back to my submissions. I just want to show you 4 decisions of this court on section 29. And as I said earlier, 3 authorities that we cited and consider to be important and don't appear in the judgment. But the first is the Dungate case at tab 4. Starts at page 20 of the authorities bundle. And this was a claim, you'll see that the plaintiff had lent various sums of money to his brother, and then the brother died, and the plaintiff issued a writ against the defendant, the widow and administrator of the brother's estate, claiming the outstanding balance of the sums lent. And then over the page in the head note, against letter B, you'll see on February the 23rd, the brother wrote a letter to the plaintiff saying, keep a check on totals and amounts I owe you, and we will have an account now and then. Sorry, I cannot do a check now. And it was held that an acknowledgement for the purposes of section 23, that's the predecessor provision, need not identify the amount of the debt, and that it was sufficient if the general indebtedness was acknowledged, provided that the amount of the debt could be ascertained by extrinsic evidence. And the words were to be construed as a statement that the brother owed the plaintiff money which he could not pay at that moment. The letter was sufficient acknowledgement. And can I just show you what Lord Justice Diplock said at page 29 of the bundle against letter H. His conclusion, I think the letter is a sufficient acknowledgement. But then it's the next page which is perhaps more important. If you turn over the page and look against letter F, there is clear authority that an acknowledgement under this Act need not identify the amount of the debt and may acknowledge a general indebtedness, provided that the amount of the debt can be ascertained by extraneous evidence. It has been possible in this case to ascertain by extraneous evidence what the indebtedness was, and the only question here is whether those words amount to an acknowledgement by George of his indebtedness to the plaintiff. In my view, they plainly do amount to such an acknowledgement. They are, despite the argument of Mr. Nevin, in my view, plainly to be construed as a statement, I owe you money which I cannot pay at the moment. To similar effect, if one looks over the page at Lord Justice Russell's judgment against letter G, it's expressed quite shortly. The letter is, in my view, equivalent to the deceased acknowledging to the plaintiff, I owe you money. This is a sufficient acknowledgement. And so we say that's important, the Dungate case. In particular, the point about adducing extraneous evidence to identify the debt in question. And then I'd just like to show you the next case is the Ross case.
Lord Justice Russell is perhaps more limited than Lord Justice Diplock. What he's considering is the establishment by extrinsic evidence of quantum.
Yes.
Not the legal nature of the claim.
That's right. That's right. No, I do accept that. In our submission, this is authority for the proposition you're right, that it's identifying the debt and the quantum. Extraneous evidence can be used for those two different things. That's right. And I was next going to take you, just in chronological order, take you to the Ross case behind tab 10, please. And I should make this point, perhaps, whilst I'm going through the authorities. A, we obviously rely on the principles, but B, it is instructive in my submission to see that the sorts of words that we use and are accepted as acknowledgements. Of course, every case turns on its facts, but in my submission, it is a useful exercise nonetheless to see what has been held to constitute a sufficient acknowledgement. So paragraph 3 just explains the introduction that this was a claim between former business partners. And you'll see paragraph 4 that it was effectively common ground that the claim was time barred, subject to a section 29 argument based on a letter dated the 1st of May. And that letter one can see at paragraph 6. Dear Mr. Ross, to our conversation when you asked me to confirm that I would pay you monies owed to you. I confirm that I'm prepared to do this as and when the funds are available to me. And then the letter goes on to say, in the circumstances, I'm happy to confirm that you suggest the following amounts are owed by me to you. And the discussion that I want to draw to your attention starts at paragraph 16. Where Mr. Uff submits the authorities establish those propositions, and it's accepted at 17 that the authorities do indeed support those propositions, and you'll see point 2 above, need not identify the amount of the debt. Extrinsic evidence is admissible to identify the acknowledgement with the debt. And point 6, the debtor must acknowledge his indebtedness and legal liability to pay the claim. And then there's reference to the Dungate case. And then over the page, you'll see under the quotation, so this is just above paragraph 19, it did not matter that the precise amount of the indebtedness was not stated in the letter. It could be ascertained by extraneous evidence. So my Lord Justice Lewison, this is a point about the amount, but then you'll see the principle that one has to read or construe a statement as a whole in its context, and then 20, the conclusion, common ground amounts to acknowledgement of some general indebtedness, and 21, the question is what would reasonably be understood by the respondent as the recipient of the letter.
And the point 3, extrinsic evidence to identify the acknowledgement of the debt, is a reference to page 1483 of Dungate to H, which says parole evidence is admissible to identify the acknowledgement with the debt and to ascertain the amount of the debt, and that comes from the judgment at the first instance of Mr. Justice Appellant.
That's right. And I just want to show you that the rest of the judgment, paragraph 22, the principal debate between the parties and before the court, it's centred on paragraph 4. In the circumstance, I'm happy to confirm that you suggest the following amounts are owed by me to you. And then you'll see at the end of 22 the way in which the conclusion is expressed. The reasonable recipient of the letter would, as I see it, have concluded that the writer intended to achieve a different result. On the other hand, I would not accept Mr. Uff's submission. That paragraph does not make reference to the claims. It is, to my mind, clear that the respondent was acknowledging indebtedness under those heads. Indeed, as I see it, he was promising to pay his debts in respect to them as soon as money was available. And then there's a reservation which I don't need to take time on. Paragraph 44, there was a slight wrinkle about quantum, which in the end didn't materially affect the outcome. The next case, if I can move forward to the Ashcroft case behind tab 12, please. The reason this case is important is because we submit, as you know, that there was only one transaction in this case that the email exchange could have been referring to. And so had the judge properly applied these principles and looked for the extraneous evidence, we say she ought to have concluded it was a reference back to the loan agreement. And The Ashcroft case raised a similar point because here a borrower from a building society failed to pay, but then started to make some part payments. So we can see this again in the head note. So borrowed money going back to 1990, failed to make any repayments of interest or capital. And you'll see in October 2000, he began to make payments of £10 per month, and those payments then ceased. And the question was whether those part payments constituted acknowledgement. And you'll see, and I'll show you the reasoning, but you'll see at Roman 2 at the very bottom of the page, the only debt to which the series of monthly payments was referable was the mortgage debt to which the claim related. No evidence had been given of any other debt owed to the respondent by A, and followed that there had been acknowledgement and part payment. And perhaps I don't need to take you through the facts again in the judgment itself, but again, you'll just see that conclusion expressed at paragraph 17. At the very, very bottom of the page, the only debt to which the series of monthly payments was referable. And we do submit that that's very similar to the facts of this case, and it's what the extraneous evidence tells us in this case. And then the final authority I'd like to show you is the Phillips case, which is behind the next tab. It's again a decision of this court, which we cited below, but it's not referred to in the judgment. And you'll see from the head note that this is an issue between solicitor and client. So the defendant had retained solicitors, and the solicitors then wrote to the defendant informing it of the amount which they claimed was due, yet to be fixed by agreement or assessment. The defendant replied, protesting about the amount claimed, but not about the fact of there being a claim at all. And the judge ultimately held that the claim did fall within section 29. The letter was an acknowledgement, and the appeal was dismissed. And if I then ask you to turn up bundle page 141, you'll see paragraph 7, which is the relevant letter. We received your letter and associated figures. The members were astonished and deeply shocked by the level of the cost claimed. They are in order of 3 to 4 times higher than was anticipated and budgeted for. And then they go on, as you'll see. They say, we simply do not have capacity to deal with both of your invoice and so on. So they put the invoice to one side. Now, there was an issue in this case about whether a solicitor's claim fell within the scope of section 29, which obviously is not a point that arises here. But if one then picks this up at paragraph 42, please. This is in the first part of the judgment dealing with the issue about solicitors, but nonetheless, in my submission, it's a general principle. It seems to me, moreover, there is force in Mr. Burns' point. When one is considering something which may count as an acknowledgement, this may arise at quite an early stage in the history of dealings between the parties about the claim. In the nature of things, since limitation is an issue, by the time the question comes to be decided, 6 or more years will have run from the date. In that context, it seems to me it would be understandable that the legislation should not require the same precision and certainty as it does for presentation of a bankruptcy petition or for consideration of what a claimant is entitled to by way of summary judgment. A claim, after all, is unilateral, and something which is to be relied on as an acknowledgement is likely to come into being relatively early on. It would be understandable if things occurring at that stage could be looked at in a more general way than is appropriate or necessary. And the reason we draw your Lordship's attention to that is we say the bar is not as high as the judge set the bar below when construing the email exchange in 2018. And then could I take you forwards in the judgment to paragraph 49. You'll see the heading was the claim acknowledged. What is most noticeable about it in this context is that the letter expresses concern about the amount, but not about the fact of there being a claim at all. If it had been entirely non-committal, then it may not have acknowledged anything. And then you'll see again references to Dungate. And then at 53, looking at the letter as I have set it out above, it does seem to me that it amounts to saying we owe you something in as much as it refers to the claim and takes issue, or indicates that issue will be taken with the amount. So that's held to be an acknowledgement. And having shown you those authorities, I'd like to just now take you back to the judge's reasoning, please. Paragraphs 150 to 150.
We're going to look at Kleinworth Benson because that's she placed considerable reliance on that.
Yes, my lord. I was actually going to come back to that later in the context of a discrete submission on Claimant Benson, if that's acceptable to the court.
Right, back to the judgment.
Well, shall I perhaps let me perhaps show you if your lordship perhaps.
Well, if you're going to come back, I mean, you do take it in your own order, as long as we're going to.
It's a discrete point on Claimant, which I'd prefer to just deal with towards the end of my submissions. But those cases that I've shown you in my submission demonstrate the general approach that should be taken to construing communications. And now if one turns up the judge's reasoning, which starts at paragraph 150 on C56, we say that there were four main errors in the reasoning of the judge, and the first we submit is a general point that runs throughout this section, these paragraphs, is we say that she seems to have applied a test that was far more stringent than the test that's required by the authorities, and in particular, the judge appears to have proceeded on the basis that the 2018 email exchange was not an acknowledgement because there was no express reference to the loan agreement. And in her permission to appeal ruling, where she refused permission to appeal, she made the point that there was also no reference to a loan in general terms. So it's not merely the loan agreement, but no reference to a loan. And what she does hold is there seems to be references to a sale, which cannot have been a reference to the loan agreement. And we say all of that it is an approach which is too strict an interpretive approach. And let me just show you the reasoning. So at 151, I'll come back to 150 on the knowledge point. But at 151, you'll see she says, Mr. Rizk referred expressly in his email to a sale, not to a loan. And his use of the words capital repayment were wholly inapposite to apply to a loan transaction. He certainly did not refer to the loan agreement. Clearly, he understood that there had been some transaction whereby the claimant had effectively divested itself of its interest in return for payment, and it may have been described to him and thought of internally as a sale, but it could not properly have been described as such if he was referring to the loan agreement. And it is inherently unlikely that he would have used those words if he had had the written agreement in mind, because the loan agreement did not provide for a sale.
Capital repayment was in a different email, though, wasn't it?
It was, my lord, yes.
I think an internal email.
That's right. You're absolutely right. That's an email exactly from Mr. Rizk forwards it to Mr. Abraham. So what one sees in 151 that the judge focusing on the lack of a reference to the loan agreement and the reference conversely to a sale. And then at 152, you'll see that in the second sentence, she refers again to the fact that the email exchange does not refer expressly to the loan agreement. And then she goes on to say at 152, she deals with an email that postdates the relevant exchange, but she says he was solely reliant on what he was told about it. So this is Mr. Rizk, the sender of the 2018 email, was solely reliant on what he was told about it by Mr. Abraham, which probably explains why he misdescribed it in 2018.
This is all going to the point that he didn't know about the loan.
Well, I'm going to come back separately to the knowledge point.
That's a separate point.
Well,
that's the only point she's making in 152.
Yes, but in my submission, just perhaps to deal with that, my lord is, your lordship's right. There are really two main strands of reasoning we submit. One is the knowledge point, which I'm going to come back to, but the other is what does the email actually say? And at this stage, I'm simply pointing out that throughout these paragraphs, the judge is saying he didn't refer to the loan agreement expressly, and that seems to have been a factor that weighed heavily in her reasoning, both at 151.
It's all one point, isn't it? The point is it doesn't refer to loan, and these two individuals didn't know about the loan agreement.
Well, in my submission, they are distinct points, but at the moment, I'm simply dealing with the question of whether the exchange needed to refer to the loan agreement or even a loan.
That depends, doesn't it, on all this goes back to the question of how would the reasonable recipient understand the acknowledgement, the supposed acknowledgement.
Absolutely, my lord.
And it seems to me the question is the judge right in taking as the reasonable recipient Mr. Risk and his knowledge? And the answer to that is, well, why do you take his limited knowledge when the corporate recipient of the email, of course, knows about the loan agreement?
So, my lord,
Because it's a party to it.
my lord, we respectfully agree that the central question is what could Mr. Rizk receives the email from Al Rajhi, which refers to the amounts due. So he's the sender from the Al Othman side. And he receives, having referred to the fact that they'd sold their shares and hadn't received their funds, he then receives an email back referring to the amount due. And we respectfully agree. The question is, what would Mr. Rizk reasonably have understood that to mean? Or specifically, would he reasonably understood that to be an acknowledgement?
It isn't what he would understand, is it? It's what a reasonable recipient would understand.
In his position, yes. And, I mean, my lord, I'm perhaps jumping ahead because I respectfully agree that that is the right question. And our submission on that point is that at 151, the judge has found that whilst he didn't refer to the loan agreement, he understood that there had been some transaction whereby the claimant had effectively divested itself of its interest in return for payment. And so our point is, the judge has made a finding. This is why I said at the outset, we're not actually asking, at least on the
That's
prime.
not so much a finding about his subjective understanding, that's a finding about what his email says objectively. And that's what matters.
Yes, but my lord, that in my submission, the finding in 151 is a point in my favour, because Mr. Rizk understood. So the judge has found that he understood that there had been some transaction, or objectively, the email that says we.
Why does it matter if he personally understood something or not, if one is applying an objective approach to an email that says you owe us money?
Yes, well, I'm content to proceed on the objective basis, but my point is that what the judge seems to have focused on is that he wasn't aware or hadn't seen the written document, and my point is that she has found that the email makes clear that he understood that some transaction had occurred, and in my submission that's good enough for our purposes, because he sends an email which indicates that some transaction has occurred, pursuant to which shares have been sold and funds haven't yet been received. He is then the recipient of the email which refers to the amount due. And if the question, which I respectfully suggest is the right question, is what would the recipient of the amount due email have understood?
Well, objectively, both emails proceed on the basis that there has been a sale. That's what Mr. Risk says. And although you stress the amount due in the reply, it's the amount due as mentioned in your email, i.e. sale proceeds. Now, your point is that there is an acknowledgement of some kind of liability. Therefore, you can inquire by extrinsic evidence what that liability is. And when you adduce the extrinsic evidence, that liability turns out to be the promise in clause 1 of the loan agreement.
If I may say so, that's the long and the short of it. And that was our point below, and that's really the point that we make on this appeal. That's exactly right.
Or to put my point perhaps in a similar way, but it comes to the same effect. It is open to parties to adopt their own conventional meaning of terms, and you say, and your objections materially reliable, but you say that when they referred to sale, they meant loan, because they were referring to the transaction which had economically divested your clients of its interest in the shares.
It's exactly the point, my lord. So if, for example, the parties had used a label, ABC transaction, if that had appeared in the email, one then looks at the extraneous evidence to work out what could they have been referring to. And in this case, as in the Ashcroft case, there is only one transaction. That's why it's crucial in my submission that the original email from Mr. Risk refers to, we have sold our shares. There is a concluded transaction pursuant to which something has happened. And that because the email is all about a new tech distribution, one then looks extraneously, well, what could this have been referring to in line with the authorities I've shown you? You say it could only have been a reference back to the loan agreement. And so it didn't need to refer to the loan agreement, it didn't need to refer to a loan. The question is, what would the reasonable, what Mr. Risk have reasonably understood? And that's really, as I said to my Lord Justice Lewison, that really is the long and the short of our point. We submit actually it's quite a straightforward case of construction. And I think I've shown you the material that in which the parties were referring to this. But can I just check? I've picked up all of the paragraphs, but you'll see, can I just continue through these paragraphs actually? Because at 153, the judge goes on to say Mr. Risk never subsequently clarified to Mr. Mattar that he was in fact referring to a loan transaction. So it's the same point. He didn't clarify that subsequently. Then at 154, no objective basis, she says, on the most expansive view as to what constitutes an acknowledgement. There is no objective basis, and that's what we say is the clear error. And I just wanted to show you, or remind you perhaps, I can just take this very quickly, but the judgment earlier, I think I did show you the relevant paragraphs and the relevant material, but the earlier paragraphs in the judgment, on the judge's own findings, except that the parties meant this sale, they were using this terminology interchangeably. That's judgment if one goes back 40, well, I won't take up time, but I can just perhaps take you back to 51, which is the September discussion. And that's when the principals agreed that this would take place to be documented in a loan structure. But that's the key discussion between the principals. So the judge has made a finding that this was understood by the parties to be a sale that's structured as a loan. And then at 86, which I've gone to already, the same point is made. And I showed you the correspondence on the 30th of September, which doesn't appear in the judgment, but shows that when the parties were communicating across the line, they were using sale and loan interchangeably. And I also showed you the Rajhi internal communications that shows the same point. Moreover, can I make this point? The construction, I referred earlier to the fact that the other sides were arguing at a trial for a positive construction, that the 2018 email exchange was referring to what they describe as the verbal agreement. But that verbal agreement takes you straight back to the discussion at 51. So even the other side were recognising in advancing their construction, their only point was the email exchange in 2018 is not referring to the loan agreement, it's referring back to this discussion between the principals in September. But in my submission, A, that was plainly wrong, and it's not being pursued on this appeal. But B, what that demonstrates is that there was common ground between the parties, that the email exchange in 2018 was referring to the exit, if I try and use perhaps a different term to sale or loan. So both parties were agreed that it was a reference back to this transaction, and the only issue between the parties was whether it was a reference to the written agreement or the verbal discussions. And one doesn't see any reference in the judgment to what the other side were advancing. And then perhaps I can deal quickly with the knowledge point, because I was going to address it separately, but to some degree we've canvassed the point already. But you'll have seen at 150 that a key point in the judge's mind was that they weren't subjectively aware of the signed agreement. And I think I've made my submissions about Mr. Risk's knowledge, and that's at 151. He was aware of a transaction, but the question's objective. And that's why, in a sense, one doesn't even need to go to our alternative argument. If we say on our primary argument, what matters is the recipient's understanding. And whether or not Mr. Rajhi or Mr. Mattar had seen the loan agreement doesn't arise, because the question is an objective reading from the recipient's perspective. That's why I say one doesn't need to overturn any of the judge's findings on knowledge, but for the reasons set out in our skeleton, if we do need to show that the Al-Rajhi side, the relevant individuals, were subjectively aware of the loan agreement. We say, for all the reasons in our skeleton, that the judge's finding was plainly wrong in that respect. Mr. Al-Rajhi was the man who had authorised Mr. Al-Sharifi to sign the agreement. I showed you that he had a conversation with Mr. Al-Sharifi. The judge's own finding on authority at 115 was premised on a conversation having taken place on the day of the loan agreement.
Well, I think my Lord Lord Justice Phillips put this to you earlier. The recipient of the acknowledgement was not Mr. Mattar alone. The recipient of the acknowledgement, alleged acknowledgement, was Othman Holding Company, a corporate entity. And so if knowledge is relevant, it's the knowledge of the corporation that is relevant, not one particular employee or director or whatever position he held within the corporation.
Exactly. I'm not sure I need to say anything more about knowledge at this stage. I can perhaps deal with anything.
Yeah, it seems to me that this has been made much more complicated than it really ought to be. And the judge has gone into a lot of analysis of who knew what, but actually standing back, it's incredibly simple. There's a loan agreement, there's an agreement between two companies, and that's what matters here. But just talking about the companies, and you say that under that, the respondent owes you money, $5 million. Very simple situation. When asked by a representative of your client, or said, you owe us money, it's not suggested there's any other money, any other agreement money. The Deputy Chief Executive of the Respondent Company, it's not suggested he was acting without authority, acknowledges the amount due. I don't actually see any difficulty with that.
Well, my Lord, I would respectfully agree. We actually,
and I don't see why the knowledge of any individual matters here.
Yeah.
These companies plainly know they had an agreement. They know that money is due on your analysis, and it's acknowledged.
That's right, and it cannot, in our submission, it cannot turn on the subjective knowledge of one individual within the company who happens to send the message. For what it's worth, we do say on these particular facts, but I respectfully agree, and I don't want to take any more time dealing with knowledge. Can I perhaps just deal with the Claimant-Benson point, and then and that will allow me to conclude my submissions. So the judge, as you will have seen at 155, described Claimant-Benson as putting the matter beyond all doubt. She clearly draws an analogy between the present case and Claimant-Benson. Now, we've addressed this at paragraph 56 of our skeleton, but perhaps I should just very quickly show you Claimant itself. And I'm sure your lordships are well familiar with Claimant-Benson, but this particular aspect, it's behind authorities tab 8. And this judgment deals with a claim brought by the bank seeking restitution of sums paid to the defendant local authority under the various interest rate swaps after the contracts had been held to be ultra vires and void. And part of the claim was resisted by the defendant on the basis that it was time barred, and the plaintiff therefore sought to argue that time was reset under section 29 because the defendant had made payments to the plaintiff under the swap contracts within the 6-year time period. And it was held by Mr. Justice Holthouse, as he then was, when the defendant local authority had made those payments, it had understood that it was discharging liability under the swap contracts. And they didn't realise at the time that there was in fact a restitutionary claim. And so what one couldn't do was take payments pursuant to the swap contracts, a completely different legal basis, and say, well, because you were paying under the swaps, you were thereby acknowledging your obligation to pay restitution, your money's back, essentially. And the crucial finding then by the judge is there are two different legal bases, and you can't rely on basis 1 to support your argument of acknowledgement under basis 2. And one can
Actually, it wasn't a case about acknowledgement at all. It It's a case about part payment.
Your Lordship's right. Your Lordship's right.
There are two possibilities in section 29(5). One is acknowledging a claim, the other is making part payments in respect of the claim. And the latter is what Claimant Benson was about.
Your Lordship's absolutely right. So there are in fact two reasons why we say it's plainly distinguishable. And my learned, just to perhaps conclude on this, we say the judge was wrong to draw an analogy because Claimant Benson was different in those two respects. But my learned friend's attempts to rely on Claimant Benson at the end of their skeleton, paragraphs 108 onwards, are with respect completely misconceived because they are trying to suggest that as in Claimant, even leaving aside the fact that Claimant's a part payment case, they're trying to suggest that in Claimant there were two different legal bases, restitution and payment under the swap contracts. And their argument here is that there were two legal bases, the written loan agreement and the non-binding verbal discussion that predated the loan agreement. And we say that is misconceived. So perhaps...
Is that what the judge got out? I thought what the judge got out of Claimant Benson was that if you acknowledge liability on one basis, here, sale, you can't then treat that as an acknowledgement of liability on a different basis, here, loan. I think that's what she got out of Claimant Benson. Didn't she?
It's unclear with respect. At 155, she says, in the same way that payment to discharge a liability under a swap contract is not an acknowledgement of the claim in restitution, acknowledgement of the claim in respect of a sale.
Yeah.
Yeah, I think your Lordship's
That's,
probably right.
that's what she's getting out
Your
of
Lordship's
Claimant
right.
Benson.
So the points that my learned friend take at 108 onwards, A, don't reflect the way in which the judge relied on Claimant, but B, we say they are misconceived in any event because this idea that there are two legal bases because there's a conversation between the principals and then a written agreement is just completely incoherent. So my lords, unless I can assist any further at this stage, those are my submissions. We say the test is clear from the authorities, which aren't cited by the judge, and we do say the analysis is erroneous for the various reasons I've advanced.
Can I just ask what the consequence will be if your appeal were to succeed? Does that mean then there will be a judgment in your favour? And is there agreement about the quantum? So it wouldn't be 5 million, but something.
Your Lordships, if I may say so, it's a very good question. We have written to the other side to try and agree the interest calculation, and they have reserved their position. As we understand it, they don't contest the basis on which interest should be calculated.
Sorry, what interest?
I wasn't thinking so much of interest.
Oh, I'm sorry.
I mean, you've got some distributions, haven't you? So they presumably will have to come back. Is that?
I think that's all agreed, my lord. I can double check, but I'm not aware there's any live issue about that.
Okay.
I'm puzzled by interest. If, as you keep telling us, this is a contract of loan, are you suggesting the lender pays interest to the borrower?
No, we say, my lord, that they have essentially owed us money since 2014, and so the interest would accrue on that basis. Again, I don't believe that that's a contentious point.
Just going back to the nature of this transaction, just can I just suggest this? I think you were suggesting that there are various ways it could be looked at, a sale that was structured as a loan, perhaps. But isn't the true analysis of this quite simple? This was a loan which was recorded as such, agreed as such, and recorded as such, but it was structured in a way so as to mimic, at least in part, the economic effects of a sale. Isn't that the true analysis?
Yes, but my lord, yes, but we do maintain that clause 1 does create a debt obligation, so that there is an immediate payment.
Well, I understand that.
Yes.
That's your submission.
Yes. We do say when one looks at everything in the round that this was a sale structured as a loan, but the parties operated on the basis that this was.
I just don't see how you can possibly say this was a sale.
Well,
It's a sale
no.
because that would have imposed obligations on you.
I'm so sorry, my lord.
The parties structured it, the parties agreed a loan, but they structured the repayment obligations under the loan in such a way that it had the economic effect, at least to some extent, of a sale.
I'm so sorry, my lord. I don't need to persuade you, and I'm not seeking to persuade you that this was a sale. It plainly wasn't a sale. What I do need to persuade you of, and what I am saying has essentially been the whole basis on which the case has proceeded, is that Clause 1 creates a debt obligation. That's it. So I don't need to persuade you that it's actually a sale, because it plainly says what it says and doesn't, there's no transfer of the ownership of the shares and so on. So it's not the sale, your lordship's right. But what I wouldn't accept is that it follows from that Clause 1 doesn't count as a debt for our purpose.
Why do you have to say it's a debt? Why can't you say it's an other liquidated pecuniary claim?
Yes, well, your lordship's probably right about that. We've put the argument on the basis of a debt, but Section 29 says what it says. Well, unless I can assist any further at this stage, there's my submissions.
Mr. West.
Please you, my lords. In terms of addressing the court, it's proposed that I will address you on grounds 1 and 2, and then my learned friend Mr. Connell, who of course appeared for the respondent trial, will address you on the short climb work Benson point that my learned friend has just addressed you on. My lords, just before coming on to ground 1, just to show you, this is a point that the court raised about what exactly was being claimed in this claim, and just to show, I entirely accept that the point was not taken at the trial, that the sort of point that the court was putting to my learned friend, that in other words this didn't give rise to a debt. I'm constrained to accept that. But can I just show you the way in which it was put in the pleadings? Just, the court may well have seen this, but just so that you have that. And this is in the core bundle, the particulars of claim are behind tab 6. And it's paragraph 13, subparagraph 4. And it's at the end of subparagraph 4. There's a reference in sub 4 to the email exchange. And your lordships will see the final sentence of subparagraph 4. The reference to the amount due was an acknowledgement under that $5 million remained due to Al Othman under the agreement, so under the loan agreement. And then
I haven't found where you are.
I beg your pardon, my lord. It's C70, page C70, tab 6. And it's the very end of paragraph 13, subparagraph 4. And then in paragraph 14, it's pleaded that insofar as necessary, Al Othman will say the email exchange between Mr. Risk and Mr. Matar, referred to in 13.4, constituted an acknowledgement of Al Othman's accrued claim to $5 million pursuant to clause 1 of the agreement within the meaning of section 29.5 of the Limitation Act. And then if one goes on to page C73, you'll see the claim in paragraph 22 that in the premises set out above, under clause 1 of the agreement, Al-Rajhi was obliged to pay the sum of $5 million to Al Othman. And then in breach of that clause, Al-Rajhi has failed to pay this sum. So the claim that's made, just to show you lordships, that was very much one under the loan agreement. And indeed, your lordships made the point to my learned friend about whether or not this was a sham, and indeed that point was dealt with in the judgment, where the judge, as your lordships may have seen, specifically refers to my learned friend eschewing any argument that the loan agreement was a sham. And just for your lordships note, that's page 29 of the judgment, paragraph 29, on page C34. And in particular, it's the final sentence of paragraph 29. So it's just to give your lordships references to that, but I'm constrained to accept that no point was taken on that below.
What does that mean?
Well,
Where are we left? Because we have, on the face of it, all of these references to a sum being payable. Yes, it is a lender is obliged to pay money to the debtor.
I,
He's paying it to the debtor.
yes,
He's not the debtor.
no, my lord, I accept that, and to the extent that your lordships find that it is not a liability which Al-Rajhi had to pay, and to the extent that you are prepared to be open to an argument to that effect, I would adopt that. But as I say, I'm entirely constrained to accept that that point wasn't taken at trial. But if the court
And is not taken by response.
and is not taken by a respondent's notice, no, my lord, that is true. I accept that, as I have to. And I don't, in those circumstances, I'm not sure that I can say an awful lot more about that particular point.
I mean, potentially it does present a problem because we are required to apply the law as we see it.
Absolutely, I accept that, my lord. I accept that. But I'm afraid I'm not sure that I can, in the circumstances, I'm afraid I don't think I can take that further with your lordships today.
Right.
Well, can I then deal with ground one, which is the complaint that the judge erred in law as regards the test, and has in particular failed to take into account or even refer to three authorities that my learned friend took him to. And I think I can probably deal with this relatively briefly. We make the points in the skeleton argument. First of all, as a general point, of course, the trial judge isn't required to refer to all of the authorities that are cited to her in the judgment. But in any event, and more importantly, obviously for the purposes of this appeal, we do submit that the judge didn't err in law in the test to be applied. And indeed, what we do say, and I'll come on to this, is that the test she applied was precisely the test which the appellant says is the test that the court should apply. My lords, just to give you some references on the point, and I know your lordships will all be well familiar with this, but on the point about the judge is not required to refer to all of the authorities or arguments, we refer you to the judgment of Sir James Mumby in Re F, and that's in the authorities bundle at tab 15, in particular paragraphs 22 and 23, page 184, and then the recent decision that I know my Lord Justice Lewison will be familiar with, which is the Municipio de Mariana and the BHP case, and in particular that's the paragraph 31 at page 199 of the bundle, and that's authorities bundle 16. What we do submit is that when one reads the judgment as a whole, it's clear that the judge didn't overlook the points made in the case as referred to, or that her failure specifically to mention them in her judgment led her into errors in terms of the test that she was to apply. In our submission, my lords, it's clear that the judge did have regard to the relevance. And one can see that from the part of the judgment analysing the issue of acknowledgement. And what the judge, my learned friend has taken you to it, and I know your lordships will have read it, but what the judge first did was set out the relevant statutory provisions that she was dealing with, so sections 29 and 30. She then refers to surrender, paragraph 142, and perhaps we could just look at this because that isn't a case that we looked at so far today. It's paragraph 142 of the judgment, page 55 of the bundle. And the judge referred to surrender for the proposition that the acknowledgement must be of the claim. And as the judge says, in other words, of the claim to the debt which is being asserted in the proceedings. I'll come back to say a little bit more about surrender in due course. The judge then refers at paragraph 142, 143 rather, to the test that she applies. And she puts it in these terms: whether there has been acknowledgement is judged objectively by reference to what would have been reasonably understood by the recipient in the context in which the alleged acknowledgement was made. And she then goes on to say this: for this purpose, however, it is also necessary to look at the position as the parties understood it at the time, irrespective of whether the law might place a different analysis on the payment. And then the judge goes on in 144 to Claimant Benson, and the reference in that case to the decision of Mr. Justice Buckley and Footman Bower. And the proposition there, and one sees this at 145, is that it's necessary to look at the act and intention of the debtor to see whether the payment was made in respect to the particular debt. And I do attach some significance to that particular passage. And then, so in that context, looking at the test as formulated by the judge in paragraph 143, we invite the court to note two things. First, in substance, that's the test that the appellant says should be applied, and one can see that from paragraph 40 of their skeleton argument. The wording is very similar. And not surprisingly, because the wording of my learned friend's skeleton argument is largely drawn from the judgment in Ross and McGrath, the first sentence of paragraph 143 is very similar to the test as formulated by Lord Justice Clarke in Ross and McGrath. And for your lordship's note, that's paragraph 21 of Ross and McGrath, page 117 of the authorities bundle.
Kleinworth Benson goes to her second sentence in paragraph 143, doesn't it?
Yes, it does.
That's what she's getting out of Kleinworth Benson.
It is, my lord. There it is. You're right. That's what she gets out of Kleinworth Benson in paragraphs 144 and 145, which is the point which is stated in Footman Bower and also in Surrender.
Yeah, and that's what she comes back to at 155.
Yes, it is. Yes.
Excuse me, on her second sentence in 143, when she says necessary to look at the position as the parties understood it at the time, what does she mean by the parties? Does she mean the companies or the individuals who sent and received the email?
Well, my lord, in my submission, what she means there, certainly in terms of the party who is said to have acknowledged, she's looking at the person who has said to have given the acknowledgement. So I would say the individuals in that case. And the reason I say that, and this is a broad point that we make in this appeal, is that we do submit it would be surprising because, sorry, just to take a step back, of course, on the factual position, the judge's factual findings, she found that the two individuals from the Al-Rajhi side who were parties to the relevant email exchange, so Mr. Mattar and Mr. Al-Rajhi, she found as a fact that neither of them was aware at the time in May 2018 that a loan agreement had been executed. And we say that's an important finding when one comes to look at the question of acknowledgement, because we do say it would be surprising if in circumstances where neither of the individuals from the Al-Rajhi side who are said to have made the acknowledgement were aware of the claim which is said to have been acknowledged. We submit that would be very surprising.
Why?
Because, my lord, effectively what one would then have is that the act of Mr. Mattar and Mr. Al-Rajhi in this case amounts to an acknowledgement of something about which they were, of a claim about which they were unaware.
But why should that matter? Because you judge it objective.
Well, my lord, it mattered.
And the person receiving it doesn't know what they know.
My lord, in terms of judging it objectively, this is the point that the judge makes in paragraph 143. That yes, one has to judge it objectively, but one also has to have regard to the position as what the parties understood the position to be at the time.
But the parties to this here must be the companies. The parties are the parties to the loan agreement and the parties who are acknowledging.
Well,
Mr.
Matter.
Mr. Mattar
isn't a party.
But he's the person who is said, it's his email that is said to have acknowledged.
Yes.
And in my
But what if it had just been somebody who'd sent it on the instructions with authority and signed, and they don't know anything, or they'd be told on instructions to.
That might be different, my lord. Of course, one has to be careful in my submission that in cases of acknowledgement that one looks at it in the particular factual context. And in your lordship's example that you just gave me, that may be the position that an acknowledgement by somebody who didn't know, if they were simply told by somebody who did know, that would properly constitute an acknowledgement.
But this seems to be a very fundamental submission, challenging, I think, basic principle. Because your submission seems to be that the subjective knowledge, intention of the sender of the acknowledgement is relevant. Whereas I suggest to you that it's absolutely clear that what they say is judged objectively, looking at it from the perspective of the reasonable recipient, who will not know what their knowledge or intention is, other than as perceived through what is written in the document.
Well, I don't accept that. And the reason I don't accept that is because the two cases, and I'll take you to these, Surrender and Footman Bower, do make clear that one has to look at the act and intention of the debtor in considering the question of whether there is an acknowledgement or not. And if one said, as your lordship puts
Yes,
it,
but objectively.
well, my lord, if one is going to characterise something as an admission, to say that a party has admitted a debt so as to stop the clock running for limitation purposes, in my submission, it has to follow that the person doing the acknowledgement knows about the claim, because otherwise one has the potential for a party to acknowledge a claim that it doesn't know exists. And
What's wrong with that if judged objectively, that's what they've done?
well, my lord, again, I don't accept that, of course, but my lord, I do say that when applying the objective test, as the judge says, based on the earlier authorities, Surrender and Footman Bower, one has to look at what the individuals concerned understood.
So do you accept that Mr. Mattar's email is an acknowledgement of an amount due under a sale arrangement?
My lord, well, Mr. Mattar's, I don't, my lord, and that's because Mr. Mattar's evidence, and your lordships will have seen this in the judgment, is that Mr. Mattar, and perhaps I can take it down, I can find that. And then there's another point, which is if that was a sale agreement, of course, what we're dealing with here is a loan
Follow
agreement.
that. And just,
And I know your lordship
just
made that
trying
point.
to
Yes.
work out what you say the email means.
My lord, the judge deals with this, Mr. Mattar's evidence on this, at paragraph 68 to 70. So in 68, this is page C41.
Yeah.
In the middle.
Yeah,
I accept-
Mr. Mattar didn't know that there was a loan agreement.
Correct, my lord.
Right.
And then in 70, Mr. Mattar was puzzled by the reference to a sale. Mr. Al-Rajhi could not recall this conversation, but according to Mr. Mattar, confirmed there had been no sale. Mr. Mattar then responded to Mr. Risk, and we've seen that, put to him that this was an implicit acceptance of an amount owing to the claimant, to which his answer was that as far as he was concerned, there was no amount owing to the claimant. He assumed the reference.
Nonsense reply in the
Well,
latter's email.
my lord, the judge makes the point that Mr. Mattar obviously found the situation confusing because he, on the basis of the knowledge that he had, but she accepted that that was his honest and genuine belief. It was the only way he could make sense of the question that had been put in Mr. Risk's email. And one sees that towards the end of paragraph 70 on page 42.
Well, this just all shows the sense in the objective test, doesn't it? Because how can you get into questions about whether somebody subjectively was confused?
Well,
What they wrote.
I accept that, my lord, but of course what I do submit is also of importance is that the party who sent the email making the claim that is being advanced, Mr. Risk, of course the judge found as a fact that there was no evidence that Mr. Risk was aware of an executed loan agreement, so the claim being advanced.
But if you look at the email exchange objectively,
Yes.
what it appears to be saying is, we sold you our shares, you haven't paid for them, and Mr. Mattar replying, you can treat the distribution as part repayment, part payment of what we otherwise, what is the amount due?
Yes.
And the amount due, as mentioned in your email, which is what I think the phrase he uses, sale proceeds.
Indeed, my lord.
So why isn't that an acknowledgement, at least, that there are monies due by way of sale proceeds?
Well, if that's right, my lord, that it's an amount due by way of sale proceeds, in my submission that wouldn't be sufficient for the purposes of 29.5.
Well, then we're on to the Kleinworth-Benson point. aren't we?
Because, my lord, under 29.5, as the authorities make clear, and Surrender deals with this, And indeed, we would submit it's clear from the wording of section 29(5) itself, there has to be an acknowledgement of the claim.
There was no issue in surrender about what the claim was.
No,
It
well,
was
there wasn't.
absolutely clear that it was a claim for freight and demurrage and other sums due under a charge party. And the only point was that if you looked at the whole message, the sender of the person sent to make the acknowledgement was saying, we don't owe you these sums because we have a set-off.
Yes.
That's got nothing to do with what claims are we talking about.
Well, my lord, in my submission, all of the cases that my learned friend refers to, there's no dispute in those cases about what claim is being advanced. Everybody, all of the parties were aware of that there was only one claim, and they knew that there was just that one claim. Whereas here, in our submission, and even if it amounts to an acknowledgement of a sale, of a claim under a sale, that isn't the same as an acknowledgement of a claim under a loan agreement, which is the claim that is being advanced and is the pleaded basis for the claim made in this case.
And that really is what the judge held.
Yes, it is, my lord. But just on the point about there only being one claim, I accept that there was only one legally binding claim. Indeed, that the judge accepts that in the judgment. But well, there was also the verbal in principle agreement that was reached in September. And it's instructive to note, and I would ask your lordship to note this, that well then for instance, well there could only possibly have been one claim. But could I ask you, your lordships, to
I think the claim form makes an alternative claim, doesn't it?
well, my lord, I'm going, if I can just show you a passage in the judgment. Yes, it's paragraph 84, my lord, page C45. Where the judge refers to a letter before action being sent on the 30th of May 2023, which referred to two things. Referred to the loan agreement, and it also referred to Mr. Massar's confirmation that the verbal agreement would be honoured. So two bases for payment are being advanced in the letter before action.
So is this a respondent to notice point?
My lord, no, because it's a question of in my submission it's not, my lord, because it's a question of it was for the claimant, for the appellant to establish at trial that there was an acknowledgement of the loan agreement, of a claim under the loan agreement under section 29(5). And the judge held that hadn't been established. And in our submission, there's no need for a respondent's notice in those submissions, in that situation, because whatever.
But aren't you seeking to uphold her decision on a different basis?
No, my lord, I'm not, with respect, my lord. I'm seeking to uphold the decision on the basis that, as the judge found, there was no acknowledgement of a claim under the loan agreement, and that was sufficient. That's all the judge had to decide under acknowledgement. This is the burden of proof point that my learned friend makes. It's not necessary in our submission for there to have been necessarily an alternative claim being advanced or an alternative construction of the email exchange. The question for the judge was, on the basis of the case being advanced by the appellant, has there been an acknowledgement within the meaning of 29(5)? And that was an acknowledgement of a claim under the loan agreement, being an acknowledgement of the claim being advanced.
But her reasoning does not include that it may have referred to the quote verbal.
It doesn't, my lord, but it does refer to the fact that there was a verbal agreement. That occurs in a number of places in the judgment. She makes that point.
Not in her reasoning on acknowledgement.
Well, on the acknowledgement, my lord, she doesn't. All she has to decide, as I say, Lord, is whether or not there was an acknowledgement of a claim under the loan agreement, whatever the other possible alternatives there might be. And she simply holds that there wasn't, which was sufficient for those purposes. That's all she needed to do. And having reached the view that there wasn't, then that meant that the limitation point didn't run.
Yeah. She does seem to think, doesn't she, in paragraph 155, that there was an acknowledgement in respect of the sale.
Well, Mel, in fairness to the judge, it may be that she's simply putting that as even if there was an acknowledgement, it was an acknowledgement of the sale, and that isn't sufficient for the purposes of section 29.5. I don't know whether, in fairness to the judge, whether she goes so far as to say that there was an acknowledgement of a liability under a sale.
See, at 146, she says this is not a claim for an amount beyond the verbal agreement.
Yes. Yes.
And she rules that out at that stage.
And to like effect, my lord, the judge makes the same point in paragraph 87 of the judgment. The present claim is not founded on this verbal agreement, but on the written loan agreement purportedly signed on behalf of the defendant.
Yeah.
So the judge is clearly alive to the fact that there was that other agreement, albeit not one that wasn't as a matter of law binding. So, my lord, I probably covered quite a bit of the ground that I was going to come on to in that exchange, which is obviously helpful. But perhaps if I can just go back for the sake of completeness to the ground one, and I was just going to take your lordships through the authorities, because we do say that the judge states the test correctly, and I can probably take them quite shortly. But the test that the judge applied was not, in our submission, far more stringent than I laid down in the authorities. Dungate was the first of the authorities that my learned friend took you to, and true it is, and particularly in the first instance judgment that my Lord Justice Males refers to, Mr. Justice Edmund Davies, he accepts that one can associate an acknowledgement with a liability by means of the use of parole evidence, and I accept that. The question, of course, is in any particular case whether that has in fact happened, and in my submission in this case it hasn't. But in terms of Dungate, as your lordships have seen, Lord Justice Diplock noted that an acknowledgement needn't identify the amount of the debt and might acknowledge a general indebtedness, provided the amount could be ascertained by extraneous evidence, which of course it could in that case. But in our submission, the general indebtedness being acknowledged must be indebtedness under the claim being advanced. That's the point that the judge makes based on surrender and so on. And in our submission in Dungate, that was clear. It was clear that the claim was being made in respect of loans that the plaintiff had made to his late brother. Both parties were fully aware of the loans, and the fact that the letter said to constitute the acknowledgement was being written in respect of the sums so lent. So in our submission, it was clear in that case that the alleged acknowledgement related to the claim being advanced. In other words, the claim for repayment of sums lent. That wasn't an issue. And indeed,
Why is it less clear here? As I understand it, on this hypothesis, you accept that your client owed $5 million to the appellant at that time.
there's the obligation under the loan agreement, yes.
And that was, no doubt about it, on this hypothesis, £5 million was due in 2014 and hadn't been paid in 2018.
Yes.
There's no other indebtedness or sums due at any stage between the
Not legally due, my lord, and obviously I make my point about the in principle non-binding agreement.
That was superseded by a loan agreement.
It was, my lord, but as your lordship has seen, that was something that's still...
Subject to that, for what it's worth. There was $5 million was due, remained due, when your client's Deputy CEO refers in an email to the amount due, isn't that clearly referring to the 5 million that's due?
Well, my lord, in my submission, no. When one reads it in context, my lord,
Aren't we in a real commercial world here with parties who don't throw away $5 million very readily?
Well,
I would assume that they don't.
well, I assume not, my lord. I assume not.
So what is the remotest uncertainty here?
Well, my lord,
in looking at that email and seeing that the amount due is the $5 million.
but it's the question of the basis upon which it is said to be due, my lord. is one aspect.
But that's not what we're dealing with now, is it, with Dungate?
Well, not with Dungate. Well, it is, my lord, because in Dungate that was never an issue. There was only one possible basis for the sums being due, and that was known by all of the participants. They were aware of
This
that.
$5 million was what was a sum which was due under what the parties were colloquially referring to as sale. It was formulated as a loan in order to deal with certain difficulties. What possible uncertainty does that raise as to what amount we're talking about?
Well, my lord, in a sense, one sees that from Mr. Mattar's own position, as the judge found on the evidence. As she found on his evidence, he didn't know what was being referred to. He didn't know that it was a claim being made under a loan agreement, or indeed under a sale agreement. And Mr. Al-Rajhi likewise, who was the other participant in the email exchange. The judge finds that he didn't know that there was an executed loan
It's an
agreement.
extraordinary finding, but fortunately we don't have to grapple with it because we're looking at objective, not through this rather bizarre subjective lens through which parties don't seem to understand the basis upon which they owe $75 million.
Well, my lord, with respect to the judge, the judge assesses it in my submission, assesses the evidence carefully. She goes through the evidence carefully, having had the benefit of seeing the witnesses in cross-examination before her. And of course not having had the benefit of seeing Mr. Mr. Risk rather, give his evidence because he wasn't called. So in my submission, my lord, the judge's judgment is a careful judgment in terms of its treatment of the facts and the finding.
Unfortunately, on this issue, not relevant.
Well, my lord, in my submission it is relevant because one comes back to the point that's made, that the judge makes based on Surrendra and Kleinworth Benson, that one has, in terms of when one is construing it objectively, one has to have regard to what the parties, and I would submit that here that involves the individuals who are said to have given the acknowledgement or to have been parties to the email that is said to constitute the acknowledgement, as to what they knew, as to whether one could, looking at it objectively in the light of that knowledge, as to what the parties were aware of when they sent the email, would the reasonable observer, looking at the matter objectively, consider that there was an acknowledgement of a liability of which the parties to the email exchange, here Mr. Risk and Mr. Al-Rajhi, were not aware on the judge's findings. That's my submission on that one. But so Dungate, in my submission, doesn't.
The objective recipient think to himself, well, there's an acknowledgement of an amount due. It's an acknowledgement of an amount due under a sale agreement. What is the sale agreement that's being talked about? It's the thing which we've been calling a sale agreement, even though actually, because we couldn't sell the shares, we structured it as a loan agreement.
Well, my lord, again, my response.
And would think, well, could it be something else? No, it couldn't be something else because there isn't anything else.
Well, no, there's no other legally binding obligation, as we know. There's as we've seen, the in principle.
So it can't be a reference to a non-binding agreement because then it wouldn't be an amount due.
Well, my lord, in those circumstances, one asks, well, why in the less before action that the judge refers to, is there also a claim being made to that sum? But I take your lordship's point on that.
That's a forensic point in response to a bad forensic point.
Well, my lord, in my submission, if in fact the objective approach is to be applied in the way which it's being put to me, the danger with that is that one then does move away, in my submission, from the approach of the courts in Surrendra and in Footman Bower, Mr. Justice Buckley and Footman Bower, which one says an acknowledgement can only acquire that characteristic by the act and intention of the debtor. And I do submit here, and at the risk of repeating myself, that there is a real danger that if in circumstances where the individuals who are said to have made the acknowledgement are not aware of the claim that is being advanced, that one reaches a situation where, notwithstanding that lack of knowledge, they don't know there's a liability on that basis, and yet they're held to have acknowledged that liability, the effect of which is obviously to postpone or to restart the limitation period.
Well, depends what you mean by that liability. Mr. Mattar appears, at least to me, to accept that Rajhi owes something. It is true that he appears to be acknowledging it on the basis that there was a sale, but the liability being acknowledged is the $5 million, which is to be paid from Rajhi to Othman. The question is, does it matter that the basis on which the sum due is misdescribed or not identified?
Lord, inevitably, my submission is that it does matter in those circumstances, because in order to come within the meaning of the section 29(5), one has to acknowledge the claim. And in my submission, the claim there is not simply to the monetary amount of the claim.
You say the claim, that is
claim.
to say the set of facts which entitles you to
Yes,
relief, and the claim is not the same as a claim.
yes, I do submit. That is my submission, my lord, yes. So we'll just very briefly on the authorities. I do submit that when one looks at Ross and McGrath and also Phillips and Ashcroft, the other three cases I'm alone referred to, it's not surprising in my submission that the judge didn't refer to them in the judgment, and it certainly doesn't lead to her judgment being impeachable on that basis, that she fails to have regard to relevant statements of authority, because in our submission she clearly approaches the question in line with applicable authority and applies the relevant test at the end of the day. The question whether she applies it correctly or not, of course, is an issue that's before your lordships. But she states the test correctly and applies that test correctly, and not more stringently in our submission. So in our submission, my lords, there's nothing in ground one. Ground two, my lords, I suspect the reality of this is that during the course of the exchanges with your lordships, we've covered a lot of the ground that I was going to cover under ground two. But your lordships will have seen that under the ground, there are 5 arguments advanced. The first is the failure, it is said, to have the judge to have regard to, or even refer to the words, the amount due. And in our submission, my lord, in fairness to the judge, she does refer to those words. She sets out the 2018 emails in which those words appear in the judgment, albeit in the section of the judgment dealing with the facts rather than the analysis of it. And one can see that at paragraph 70 of the judgment, and that's page 41. She doesn't set out again the specific words in the analysis of the limitation point part of her judgment, because she's already done it. And in our submission, it really can't be suggested that she didn't have them fully in mind when undertaking her assessment of the exchange. Particularly, we would submit, given that the email was the only matter relied on by the appellant as constituting an acknowledgement, and the email itself was so short. As to the phrase, the argument that the phrase "the amount due" is an unequivocal admission, I covered, I think, that in some detail in response to your lordship's questions. All I would say on that is that, and I would refer your lordships to Footman Bower and Surrendra, because it is, as a matter of what those two cases say, and as based on the wording of the statute, the debtor has to acknowledge the claim. And Footman Bower, and perhaps I should just take your lordships to it just to show you the relevant passage. It's tab 3 of the authorities bundle, page 9. Decision of Mr. Justice Buckley, albeit under the predecessor provision, so the 1939 Act. And it's the that was a promise, that was a payment. One looks at page 449, I think. One can see in the passage just below at halfway down. In my judgment, one must still look at the act and intention of the debtor to see whether the payment is made in respect of the particular debt.
Sorry, which page are you on?
I beg your pardon, my lord, page 15.
Okay.
Page 15. Page 449 of the report.
Yep, I've got it. Thanks.
One must still look at the act and intention of the debtor to see whether the payment is made in respect of the particular debt. Payment is in this subsection dealt with in close conjunction with acknowledgement. Just as an acknowledgement can only acquire that character by the act of the debtor or his agent, so I think a payment can, for the purpose of the section, only acquire the characteristic of being made in respect of the debt by the act of the debtor or his agent. And then to look at Surrendra, at tab 5, page 33 of the authorities bundle. Just at the top of page 41 in the bundle, page 573 of the judgment, the judge says, I deal first with the question of acknowledgement. To acknowledge a claim as a matter of ordinary English words signifies an admission that it is due. And then one can go on to page 43, where the judge sets out what he draws from the authorities that he refers to. The debtor must acknowledge his indebtedness and legal liability to pay the claim in question. No need to go further back to seek an implied promise, as used to be the position under the previous law. But taking the debtor's statement as a whole, as it must be, he can only be held to have acknowledged the claim if he has in effect admitted his legal liability to pay that which the plaintiff seeks to recover.
So what this amounts to is that if you have correspondence between two lay people, okay, no knowledge of the law at all, there's only one debt, but the person, because of the acknowledgement, misdescribes the basis of liability, then it's not acknowledged.
I don't go that far, Marlon. I don't go that far. If in fact there is only one possible basis for a claim, and I don't accept here that there was only one legally binding agreement, but there was also the verbal agreement. But in the case that your lordship puts to me, I accept that if the case of two lay people, where there is only one possible claim, both parties are fully aware of that, then an acknowledgement that says, for example, say the claim is for £50,000, and it's acknowledged that £50,000 is due. The court, if it came to the court, performing the exercise of deciding whether or not that amounted to an acknowledgement within the meaning of section 29.5, I can well see that in those circumstances, the court may decide that it is an acknowledgement of the claim that is being made, and therefore an acknowledgement that satisfies 29.5. But here, of course, not only does one have the different potential bases, albeit only one legally binding, but one also has the position that the two individuals on the Al-Rajhi side and Mr. Risk on the claimant side, so the three individuals who were parties to the email exchange said to constitute that acknowledgement, were not aware of the loan agreement. So they weren't aware of the claim that was being advanced, the basis for it.
But still, at the end of the day, the judge has effectively said, well, because it referred to a sale rather than a loan, it's not an acknowledgement.
That's one of the reasons for the judge reaching that conclusion, my lord, yes.
Is it inherent in your position that if a claim is advanced to the alternative, it can never be acknowledged?
I don't think it would be inherent in that, my lord, no. But obviously one has to be careful that it would all depend on the particular way in which the relevant exchange is formulated. And because all of these questions turn on their particular factual context. So I'm not trying to avoid your lordship's question. I just think one has to exercise a degree of caution in terms of necessarily accepting broad propositions or making broad propositions. Because and I think it's in the Phillips case where Lord Justice Lloyd refers to a decision of the House of Lords to say that one has to be very careful about treating words of acknowledgement in one case as necessarily being words of acknowledgement in another. So I'm not avoiding your lordship's question. I just think it would all depend on the particular context.
Do you accept that there's nothing in surrender which bears on the situation where there is some uncertainty about the nature or basis of the claim, or any ambiguity about what is being claimed? Because I can't see it at the moment, but if there is something, I would like to see it.
I agree with your lordship in terms of on the facts of surrender, that there wasn't any ambiguity there. But what I do take from surrender, my lord, albeit I accept, as your lordship puts me, that it wasn't in the context of a case where there was ambiguity. But
you're putting quite a lot of weight on the words "the claim in question," which I think you emphasised when you read them.
I did, my lord, and I do put emphasis on that. But I also put emphasis on the point that's made, and this comes through at the quotation from. This is page 577 of the report, page 45 of the authorities bundle, where the judge refers to the judgment of Mr. Justice Buckley and Footman Bower. Because again, he says there, quoting, that it's the passage that one must still look at the act and intention of the debtor to see whether the payment is made in respect of the particular debt. And that's what I.
I was going to ask you about that. In here, Mr. Mattar says apply the distribution against the amount due. Well, what is he saying that should be applied against? It's the particular debt, isn't it? There is only one debt.
Well, my lord, certainly as far as, and again, if one looks at for example, the judge's findings as to what Mr. Mattar understood to be the case, that's the passage that I think I took your lordships to earlier. At paragraph 70 of the judgment at 42. He assumed the reference to interest must be to the claimant wanting to treat the dividend as interest on its investment.
But that's not what he said
It isn't.
in his email.
No, his email says what it says. But that was his understanding of, as the judge makes the point, he was obviously confused given his state of knowledge at the time and his lack of awareness.
I find it very difficult to see how, when Mr. Mattar is saying you can apply this money against amounts due, if that's anything other than as against sums due in respect of the debt that you're now being sued for. How can it be anything but that?
Well, my lord, it's not a debt that is being sued for at that stage. Well, maybe I misunderstood your
In
lordship.
fact, the sentence reflects the structure of the loan agreement, which was to be repaid out of distributions.
Under the loan agreement, this sum should have gone. That dividend should have gone, whether via the appellant or not in front of your client immediately.
Yes.
And it's been said that actually keep it applied against the amount due.
Well, my lord, in terms of interest, interestingly, when one looks at the loan agreement, of course, the loan agreement, this is page 6 of the supplementary bundle, expressly provides that the loan shall not bear interest.
We're not
No.
talking about that.
But it does provide that the loan, the principal sum, will be repaid out of distributions.
Yes.
And so a distribution would be applied towards the amount of the loan.
Well, my lord, I'm not sure I can assist you further, as your lordship makes the point that the wording of the email is as it is. Order. Could I just take instructions, my lord? I think I may have, because of the way in which your lordships have asked me questions, have covered the points that I wanted
Right.
to make, albeit not in the. Well, unless I can assist you further, those are my submissions on grounds 1 and 2. Of course, Mr. Connell
Yes.
is going to address you on that.
Yes, Mr. Connell.
Good afternoon, Your Lordships. I'll be addressing ground 3, which concerns what has been described as the Kleinwort-Benson analogy in reference
Yes.
to the judgment of Mr. Justice Hobhouse in Kleinwort-Benson and South Tyneside Metropolitan Borough Council. This is addressed in our skeleton argument, paragraphs 104 to 116. And effectively, in summary, the respondent's position on this ground is, first, on a straightforward reading of the judgment below, the judge reached her conclusion by applying the statute and the principles outlined in surrender. And the analogy with Kleinwort-Benson was a capstone to our analysis, such that even if the appellant were to be successful on ground 3, it does not dislodge the judge's underlying conclusion. Our second point is that in any event, we submit that the judge's analogy with Kleinwort-Benson was apposite, and she was correct to draw that analogy, and the points of distinction being raised by my learned friend for the appellant do not withstand appropriate scrutiny. As to the first of the points, the judge referred to the decision in Kleinwort-Benson, as already indicated by your lordship, paragraphs 144, 145 and 155 of the judgment. And we see at paragraph 155, the judge stated as follows: "It is not good enough in my judgment to argue that both parties had in mind an agreement whereby Al Othman could achieve an economic exit. The statute is quite clear that what is required is an acknowledgement of the claim being asserted." And then she goes on and says, "And Kleinwort-Benson really puts the matter beyond all doubt. In the same way that payment to discharge a liability under a swap contract is not an acknowledgement of a claim in restitution, acknowledgement of a claim in respect of a sale can hardly amount to acknowledgement of a claim under a contract of loan." And it's evident from that paragraph, we submit, that the judge had reached her conclusion by applying the statute informed by the well-known principles in surrender, and Kleinwort-Benson is expressly referred to as an authority which puts the matter beyond doubt, not an authority on which the judge is placing primary reliance upon reaching that conclusion. Therefore, even if the judge was wrong to consider the judgment in Kleinwort-Benson to be analogous, it does not dislodge the conclusion she reached. As to the second point, which I understand to be a matter of significant interest from your lordships, we say that the analogy drawn with Kleinwort-Benson was apposite, and that the judge was right to consider that Kleinwort-Benson put the matter beyond doubt. The appellant seeks to distinguish Kleinwort-Benson on the basis that, unlike in Kleinwort-Benson, Al Othman does not have and has never had two different legal bases for seeking payment from Al Rajhi in respect to the Al Salam shares. Now, our position is that this analysis is wrong for a number of reasons. First, we would say Kleinwort-Benson does not turn on there being more than one legal basis for seeking payment, where the other potential basis that could have been available to the bank under the interest rate swap contract was effectively a contract which was void ab initio. that was not available to the bank. But in any event, Mr. Justice Hobhouse in Claimant Benson was applying the reasoning found in both Footman and in Surrendra. In short, Claimant Benson is helpful authority for the proposition that an alleged acknowledgement must acknowledge the basis for the debt claimed, not some other claim, legal, enforceable, unenforceable, or otherwise. And it may be useful to turn to the authority. I appreciate your lordships were brought to it earlier on by my learned friend Mr. Singler. It's behind tab 8, and the relevant page is page 70, which we can see from the head note, and as your lordships are familiar, this concerned 5 interest rate swap contracts between the bank and the relevant local authority, and it transpired that those contracts were void as being ultra vires, and that the bank was therefore required to pursue a restitutionary claim. We can helpfully take up the analysis on page 78. And we look at C towards the top of the page. In that case, it is not in dispute that when the defendants were making these payments, they thought that they were discharging a legal liability under the KB1 contract. They did not realise at the time that it was void, and they were wholly unaware of any restitutionary right that the plaintiffs might have against them. Therefore, the plaintiff's argument has to be put on the basis of what is now known to be the legal position and the effect which the law would now attach to those payments.
Is that a subjective or an objective conclusion about the defendant's understanding? Undoubtedly, it was their subjective understanding, but it would also have been the objective understanding of the parties at the time, because nobody had thought of any possible claim in restitution, and nobody had thought that there was any doubt about the validity of the swaps.
Your lordship's quite right. It is both subjective and objective, which is perhaps indicative by virtue of the words they did not realise at that time. Of course, as a matter of objective reality, these contracts were ultra vires, but clearly there is some relevance being paid to what was understood at the time. And the reason why that is perhaps relevant is when the court then turns to look at, on page 79, the relevant test. And we can see at B, effectively, the court has cited from the Footman case. Therefore, Buckley J was deciding that it was still necessary to look at the act and intention of the debtor to see whether the payment was made in respect of the particular debt. I appreciate this is a point my friend Mr. Westwood has already raised, which is the relevance or otherwise of the position of the debtor.
But you judge it objectively.
You do judge it objectively, but part and parcel of judging it objectively is to actually understand what the position was in respect of the debtor's position at that point in time. And what's notable here, I think, is if we just stay with the authority for a moment, Mr. Justice Hobhouse goes on and effectively gives the ratio in the next paragraph. It was clear that unless one can conclude that the payments made by the defendants to the plaintiffs evidence an acknowledgement by the defendants of a liability to make restitution to the plaintiffs of sums earlier received by the defendants, the payments cannot be viewed as having been in respect of that liability. And your lordship raised earlier on the perspective in relation to the fact that section 29(5) involves 2 potential ways in which a debt can be acknowledged. One by way of payment and one, of course, by way of acknowledgement. It's within the same subsection, we would say, that the court is addressing this point. Obviously, in Claimant Benson, the court was dealing with part payments, but we would say in terms of the ratio and in terms of where Mr. Justice Hobhouse reaches his conclusion, that distinction as between whether it was payments or whether it's an acknowledgement is not one that makes a difference or distinction to his conclusion in respect of finding that in this instance the limitation defence failed in respect of various the plaintiff's answer to the limitation defence failed, and the plaintiff's claim in respect of the payments made was thereby limited. think there was a
In
sum of about 8,000.
Footman Bower, Mr. Justice Buckley also remarked on the fact that payment and acknowledgement are dealt with together, and he equated what was necessary, the test for acknowledgement or payment, as it being effectively the same test.
That's precisely right, and we're dealing with the same subsection, we would say, in relation to this.
But in Claimant Benson, the defendants didn't know and couldn't have been expected to know that they would eventually be liable on restitution.
Yeah.
But here, your client knows that it entered into a loan agreement and it knew that it was liable for 5 million on the hypothesis we're acting on. So it knew all the facts.
Well, we need to be careful in relation to what was the position, and it's notable if we look at the email exchange itself. There's a very helpful full copy in the supplementary bundle at page 43, as we get some of the internal traffic from Al Othman in relation to this.
How does that?
Behind tab 12, as to what parties knew and didn't know, and what the relevant individuals involved in the exchanges, both behind the scenes and in the email.
I don't understand why. We know you're not saying that your client didn't know it entered into a loan agreement. It signed the loan.
That's correct, and the point regarding authority was obviously decided against us, and we're not seeking to reopen that. It is correct that at a corporate level they signed a loan agreement, but what's not accepted, and this is a very important point, Your Lordship, what is not accepted is that in referring to a sale, they were referring synonymously to a loan agreement. There were two distinct things, we would suggest. And what's notable from the exchange at supplementary bundle 43, and bear in mind this is in response to an email that Mr. Matter has sent to all the various shareholders saying, here's some distributions. We have that over the page at page 44. The response from Mr. Rizek, which is at the bottom of the page, bear in mind Mr. Rizek was not called to give evidence at trial. He indicates, as you know, we already sold our shares to Rajhi Holdings. Just pausing there. No sale could ever have occurred for the reasons outlined by Your Lordship, because of course there was a shareholders agreement that precluded the concept of a sale without certain obligations being triggered. Yes, you could have a sale, but you would then need to notify other shareholders, and that was clearly something which was a relevant part of the factual matrix recorded in the judgment.
Is this point going to take you more than about 5 minutes, Mr.
I'm going to take it very shortly, but effectively the correspondence from Mr. Rizek is there has been a sale of shares that never occurred. We did not get our funds yet. Will the below dividends be considered as interest? As my learned friend pointed out, interest wasn't payable under the loan agreement at all. The response from Mr. Matter is above it, and he says, based on my understanding from Khalil al-Rajhi, this amount is to be considered towards the amount due, as mentioned below in your email. So he's referring back to a sale. We then have Mr. Rizek forwarding that on internally to Mr. Abraham, who gave evidence, was found to be a witness lacking in credibility. Says, Dear George, your thoughts. I sent him an email for a call. He did not reply. I want to consider the below as interest, not capital repayment. And bear in mind, the sum was never advanced under the loan agreement, never advanced by Rajhi. Mr. Abraham's response, just get the money and we will handle it at a higher level. Please send the account details and keep records. So when they're discussing a sale in this context, that's entirely fictitious, never occurred. There is no sale. There was no sale.
We all know what happened here, and we all know what this is talking about.
Well, my submission, Your Lordship,
It's requiring us requiring us to assume a degree of ignorance on the behalf of two corporate entities, and for the court to treat itself as being ignorant of what plainly happened and what the parties are referring to. We know that the parties wanted to do a sale but couldn't, so had a loan agreement, and we know that this is what it's referring to. No doubt about it.
If this internal exchange is admissible at all, it would seem to suggest that Mr. Risk's understanding was that the dividend was to be treated as part repayment of the loan. But he says he wants to consider it as interest, not capital repayment. Well, capital repayment can only refer to a loan.
But in this, it's entirely confused, and I take issue briefly with your lordship's characterisation that they all knew what was going on. This exchange indicates that they didn't, and the reason why it's not a capital repayment is, of course, no capital was ever advanced under the loan. So he's got it completely the wrong way around. And moreover, we would say the entirety of the exchange needs to be considered. He's talking about a sale of shares.
Yeah.
We have sold our shares. You need to pay us the purchase price for those shares. That just never occurred.
Yeah.
It didn't happen. And that's why Claimant Benson is an opposite analogy. Because in Claimant Benson, when the council was paying the sums under the swap contracts, what was happening? It was paying those sums because they thought there was a valid contract that existed. Mr. Rizek here is thinking that there has been a valid sale that has occurred. It did not occur. There was no sale. So we say the point in relation to this is that where my learned friend makes the point that there's no other alternative, there are alternatives. In fact, there's one that's an entirely fictitious alternative, which is a sale. You've heard from my learned friend in relation to the non-binding verbal agreement recorded in paragraphs 86 and 87 of the judgment. And we say the judge was right in making the finding that effectively Claimant Benson took the matter beyond doubt because, as she found, she was dealing with exchanges to do with the sale that never occurred. The claim is to do with the debt under the loan agreement.
All right,
That's on that
we'll leave
basis.
it there. Come back at 2:05.
Very good.
Authorised is able.